Welcome, everyone.
Hi.
This is Renata, and my name is Massimo. We have an all-Italian lineup today. We are both from the OH&S team at the Victorian Trades Council. Welcome, everyone, to our first webinar for our OH&S Basics Month series, which starts today. Firstly, I would like to thank our sponsor, Slater & Gordon. I would also like to acknowledging the traditional custodians on the land on where we meet today, the Wurundjeri people of the Kulin Nation. We pay our respect to the elders past and present. We extend all the respect to all the Aboriginal and Torres Strait Islander people that might be with us today. This land was stolen, sovereignty was never ceded, and always was and always will be Aboriginal land. Before introducing our presenter today, just a couple of housekeeping rules. So we're gonna record this webinar so that we can upload it and share it on our pages. There will be a Q&A after the presentation, so I encourage everyone to put your questions in the chat. We're gonna try to reply to as many as we can, always being conscious that the webinar will finish around 5 p.m. If there's any question, again, put it in the chat. I am just gonna cut it and introduce our amazing presenter today, Renata Mussolino, OH&S organizer. She's been at the OH&S team at Victorian Trades Council for over 2 decades. She's an absolute legend, a great expert, and I think we are very thrilled to have her as the first speaker for this month. We're gonna go through some OH&S basics today with Renata, duties of employer, the power of health and safety representatives. But I think I'm gonna just leave it to you, Renata, and thank you very much.
Thank you, Massimo. Okay, well, welcome everyone. As Massimo said, this is our first session. Any questions that we don't have time to answer, if you put them in the chat, Liz, I think you should be able to keep them and we can answer them later. So we will answer them later using emails if you provide that. Okay, so we'll start. We've got a slide presentation and this should be available as well if you need it. Okay, so we'll get going. Now, I will assume that some of you probably know quite a lot and some of you don't know very much. But as Massimo said, today we'll be talking about rights at work, the OHS legislation in Victoria, and what rights and responsibilities workers and health and safety reps have. Yeah, go on. Okay, so why is health and safety such an important and a union issue? Well, firstly, consistently, workers say that OC health and safety is in the top 3 in terms of what things are important to them. They might mention pay, they might mention job security, but occupational health and safety is there. It is a fundamental right to be able to come home from work in the same condition as when you left. We know that there are fatalities and they are tragic, but they should never have happened. You also have the right to information and the right to be consulted. These are pretty fundamental things. Oops, we skipped one. Okay, so annually in Australia, there are about 200 or so deaths at work. This is likely to be a big underestimation. Now, when I first started doing these presentations, about 20 years ago, that number 200 was actually 350. So in terms of workplace fatalities, they have reduced. But of course, this is not the whole picture. I couldn't get Australia's figures or estimates today, but the ILO has estimated that there are almost 3 million work-related deaths every year in the world. Now, of these, only 330,000 are workplace fatalities. The rest, so 2.6 million, are attributed to work-related diseases. So we see that the percentages, if we have 200 fatalities, well, then how many deaths are in fact related to work? A lot. Nationally, there were 139,000 serious claims last year. Those results have just been published by Safe Work Australia. Even based on inadequate workers' comp statistics, 35,500 claims were made in Victoria. These were successful work cover claims last year. That's a lot. Of these, almost 6,000 were for mental injuries, and these are growing. Many workers we know don't put in claims. Why? Well, the answer is obvious. Often people don't get help. They're too frightened to put in claims, or their claims get rejected, and so they don't get counted in these figures. So we know that there are very large numbers of people. That's why health and safety is important, because it's not about compensation, it's about prevention. So getting injured at work or suffering a work-related illness can affect a worker's ability to work, clearly, to socialise, to participate in life, to form and maintain relationships. It can have terrible effects on families. So where does OH&S come in the law? Well, firstly, we have common law, and there's a common law right that says, or a common law duty on employers that says that employers must take reasonable care for health and safety. Pretty broad, not much information. Then we have statute law. Now, statute law is established by Parliament, so there are acts and our regulations. It is far more specific than the common law, and it is often the result of union and worker campaigns. If we listen to governments would do what they want to do. Employers would prevent it. They hate when we have legislation in health and safety. So really, the laws that we have are the direct result of the sorts of work that unions and workers do. So how is OH&S covered in our law? So we mentioned common law. You also have the right to immediately stop unsafe work, which is really important. The Fair Work Act has a section on workplace rights that also applies to health and safety laws. In fact, many unions find that taking matters up in the industrial courts can give better results than regulators. There's workers' compensation laws, and then there are privacy laws and anti-discrimination laws. Have to remember that OH&S is a jurisdictional responsibility. That is, each different state and territory has their OC Health and Safety laws. So in Victoria, most workers are covered by the Victorian OC Health and Safety Act and our regs and our codes. But those are employed by federal government departments or government business enterprises, and also some national companies that have had self-insurer status granted. They're covered by the Commonwealth Workers' Compensation and OH&S Acts. Now, the laws are similar, but they're not the same. So if you do work for a federal organisation or for something like, I don't know, I can't remember the big companies now that are covered, you don't come under the Victorian Act. Now, this is just a slide which I won't go through, but we first had our Act introduced here in 1985. Before that, we had bits and pieces. So our Act as we know it looks very much like the first Act in 85. Since then, there's been a review. We've got a new Act. We've got new consolidated regulations. We used to have all bits and pieces of regs. Now they're in that big fat white book. And we've also had compliance codes, which replace the old codes of practice. Interestingly, other states still call them codes of practice. Ours are stronger because they set out what an employer needs to do if they want to comply with their duties under the law. Yeah. Massimo's being my slide mover. Okay, so what does the occupational health and safety have? The main parts really are the duties of employers, duties of third parties, duties of employees, consultative arrangements in the workplace, resolution of OH&S issues. They're really important aspects in our Act. Right at the beginning, under Section 20, it sets out two very fundamental principles, and these are to eliminate risks to health and safety so far as is reasonably practicable. So it's about eliminate, and to reduce those risks if it's not reasonably practicable to eliminate them. Now, reasonably practicable comes up in all our laws, through the Act and through the regulations. It's not simply about what the employer can afford to do or what they can claim to be able to afford to do. There's a really good document on the WorkSafe website that you can get to through our website that explains what reasonably practicable means. And it means taking into account the severity of the risk or the hazard, the knowledge about how you control it, a whole lot of things. Cost is one, but it's the very last one. So our Act makes it clear, if you look at a workplace, who has most control in the workplace? It's the employer, okay? The employer makes most of the decisions, what to buy, what not to buy, what shifts to have, how many workers to employ, all sorts of things. So the Act says, okay, they've got the highest level of control, therefore they have to have the greatest level of legal responsibility. So Section 21 of the Act says, the employer shall provide and maintain, so far as is reasonably practicable, a working environment that is safe and without risk to health. That's the employer's duty of care. And it includes a whole range of things: safe plant, substances and systems of work, keeping the workplace safe, adequate facilities, information, instruction, training and supervision, monitoring health, keeping records, employing qualified people, nominating a management rep, monitoring conditions, safe access and exit to the workplace, and remembering that health very clearly includes psychological health. That was inserted in the Act to make it absolutely clear. It's not just about physical health. So it covers, therefore, things like harassment, discrimination, bullying, and stress. Other parties, designers and manufacturers, importers, suppliers of plant and substances also have duties too. I'm an employer. I buy a new piece of equipment. I should expect that it's not going to kill a worker or cut their arm off when I buy it. So that explains that. The legislation puts duties on workers as well. So as a worker, you have a duty, but it recognises that you don't actually have much power. What can you control? You control yourself. That's about all. So must take reasonable care for their own health and safety and that of others, must cooperate with the employer regarding anything they introduce for health and safety, and must not willingly or recklessly misuse or place at risk the health and safety of any person. Of course, that's always dependent on how much information, training, supervision, and so on workers have. The Act also takes into account this idea of a hierarchy of control, particularly in some of the regulations where this is spelt out. But occupational health and safety experts, and all of us who aren't perhaps so expert, we understand that the best way to deal with a hazard and a risk is to eliminate it. And in fact, you saw at Section 20, elimination comes first. If you can't eliminate, well, then you need to go down the hierarchy. So the hierarchy is elimination. So get rid of, if you're using a chemical that's poisonous, well, then eliminate it. You don't have to use it. If you need to, you can substitute it with something else that maybe isn't so good, like you wouldn't drink it or pour it all over yourself, but it's not going to kill you. You know, some chemicals can kill you with a drop. They're that bad. After substitution, there's engineering controls. So things like sound reduction or a machine that's been redesigned so it's not as noisy. Then there come administrative controls, changing the way people work or isolating workers from where they're working. And the final one is personal protective equipment. Unfortunately, many studies that we've done in Australia show that PPE is often the first thing that employers do. They'll give workers gloves and goggles rather than replace the chemical. So that's the lowest order of control because more things can go wrong. Along there, you'll see that what should happen is that workers need to be trained and supervised, whether it's at the very top of the hierarchy or the bottom of the hierarchy. So, as we said, the higher order, we call them the higher order controls. They're the ones that change the environment, that reduce the risk or the hazard as close to the source as possible. The lower order controls, they don't eliminate the source, and they rely much more on worker behaviour, maintenance programs, supervision, and they can be compromised by pressures or by the lack of suitability. So, for example, PPE isn't suitable for many people because we're not the same size or the same fit. PPE can break down, you know. I know I've heard of terrible examples where people are using masks that should have been replaced months ago. So they're not very effective. Just to know that in addition to the OH&S Act, we have the Dangerous Goods Act, which we always call secret experts business because it's so complicated, and also the consolidated regulations, which I mentioned before, and they cover a whole range of regulations from manual handling, plant machinery, hazardous industries, a lot more. If you don't know them, they're very interesting to look at, and they do have spelt out in them, in some of them, the hierarchies. So for example, with the prevention of falls regulations, the employer has to try and change the work so that workers aren't doing a job at a height, if possible. So they have a hierarchy there. And same with noise, same with asbestos, and so on. Okay, so who should workers be talking to if they have an issue? Well, you can talk directly with your employer, you can talk directly with your supervisor, but who you should be talking to, first off, is the elected health and safety rep. And that's because the elected health and safety rep has got a very important role in the workplace. The Act gives elected reps a lot of powers and a lot of rights to be able to take matters up. In fact, the resolution of issues process, even in the Act, says that workers should take things to their rep where possible. If you go directly to the employer may put pressure on you, may not follow up, and so on. And of course, talking to the union that covers the workplace. So what is a health and safety rep? It's basically a person who's elected by a designated work group. And what's a designated work group? Well, I just had to use it today to answer someone's question. It's a number of workers. A DWG is defined as a number of workers who have been grouped together for a particular reason, and that DWG can elect a health and safety rep whose role it is, not job, mind you, whose role it is to represent them to the employer on anything to do with health and safety. So what are the sorts of things that a rep has the right to? Sections 58 and 59 are the two important sections. They represent the group, they have the right to access information. Drives me crazy. We tried to get the government to change that to actually say the employer has to give the rep information. Providing access is so passive. How do you know what information you want unless you know that the information is there? Anyway, they can take time off with pay to exercise their powers. So things like inspecting the workplace or talking with people, attending training, attending committee meetings, be present at interviews regarding health and safety. They can inquire into hazards and risks. They can take issues and attempt to resolve them. There's a whole section on that. If they can't resolve, they have to take the issue first, then they can take more action. They can do things like issue what we call provisional improvement notices, which are formal notification to the employer that something has to be done. Or in cases where there is an immediate risk to health and safety, they can issue a direction to cease work. Really powerful stuff. Not even Liberal governments remove this right from reps. So reps are very responsible. They do not misuse their rights and powers. One thing we haven't mentioned here, and that is because there's going to be a whole separate session on it, and that is that reps also have the right and employers have the duty to consult on a whole range of things before proposing, before making changes, when identifying risks, when looking at methods of consultation at the workplace. A whole range of things, really super important, and Massimo will be organising, I can't remember which one it is, but it's in one of the upcoming sessions. Okay, so under section 69, employers also have obligations to the health and safety rep. These include allowing a person who's assisting a rep to access the workplace, not any person, of course, but someone who's got adequate knowledge of health and safety. So your union organiser, particularly someone who's done the REO training, is a perfect example, but also people like experts. But beware, because if you call an expert in, then someone's going to have to pay that expert. Also to keep and display at the workplace a written list of each HSR and deputy for each DWG. So my best advice to workers is to join a union, because you may or may not be surprised to learn that workplaces with health and safety reps are usually unionised workplaces, because the whole system of getting a health and safety rep, of having DWGs, is kicked off by a request from employees. Now, it comes back to, you don't know what you don't know unless you know that you don't know, one of those weird things. So a lot of smaller workplaces, the workers there have no idea what the laws are that protect them, what rights they have, and what they can do to take the matter into their own hands. A lot of people just sort of wait and they think, oh, well, government will come and sort things out, but that's not what happens. So if you join a union, well, then those people who are unionised will have access to the union. The union can go in there, tell them about what's there, tell them about their rights, help them to establish designated work groups and elect health and safety reps. Plus, of course, we have to remember that it was unions, workers through their unions, that achieved many of the things that we now take for granted. Things like wages, good wages, health and safety legislation. We didn't have this until we had governments that listened to workers and unions. Public holidays, penalty rates, superannuation, you name it, it was achieved through worker struggles and unions pressuring government. So the list goes on and on and on, and if we're not careful, we'll lose stuff. So unions give workers a voice. We provide information, we provide advice, and we provide help when, not if, you have a problem. Okay, now that's the end of the formal presentation. What Massimo has put up there is a QR code. We're going to do Q&A in a minute, but while this is up, you can just take a snap of that, because then we'll ask people to fill out the survey, right?
Yes.
Can you explain what we'll do with the survey?
Okay, I'm gonna leave the QR code for a minute. So every time that we do a presentation, an event, a webinar, and we do collect data, we could collect feedback, because every piece of feedback and advice that we get from people that participate to our events, we then compile it into data that can help us pushing for change. So every time that we push for a change in policy, or that we have any suggestion for government to change, it always comes from workers. So doing these feedbacks is really important for us, because it's going to help us and each Victorian worker to try and improve legislation and working condition.
Yeah, the other thing too, which I don't know if I should mention, but of course we're very lucky at the moment to have a government that has consistently funded our unit, and it's very important for us to be able to demonstrate to our funding body, which is WorkSafe Victoria, that we do engage with workers, that we run activities that workers are interested in and participate in, and that our activities and our webinars and our conferences are good and worthwhile. So it's great to have you all here. I'm really pleased to see quite a lot of people here and who are participating. So it's important for us to also gather data on what it is that people want, and also for us to think, well, okay, people have said we want a bit more of this, so when we're developing the next lot, we take that into account, because we do want to listen to what you want and what you want from us.
Okay, so we can open it for questions in a minute.
Or comments.